This is a section on courts and alternative dispute resolution. This integrity audio session will cover approximately the first half of this presentation. We're going to skip the first couple of slides. It's interesting reading. It's more of a discussion of history and civics. And then we're going to move on to some practical elements that everyone needs to know concerning jurisdiction, venue, and standing. Jurisdiction is the power of a court, synonymous with power. It's the power of a court or the power of a judge to hear a case. Without having jurisdiction, a court cannot entertain the case and cannot resolve the case on the merits. You've got to have personal jurisdiction, property matter, and subject matter jurisdiction for a court to be able to hear the case. In general, courts will either have limited jurisdiction or general jurisdiction. In the state of Alabama, for example, the circuit courts, our state circuit courts, are courts of general jurisdiction. That means that they can hear practically any kind of case without limitation. Our state circuit courts, depending upon the county, may hear a divorce case one day and then a multi-million-dollar class action lawsuit the next day. On the other hand, a court of limited jurisdiction is limited generally in what subjects they can hear. For example, a divorce court or a probate court, sometimes criminal courts, drug court, municipal court, etc. For example, if you wanted to have a probate court, probate courts generally hear wills, estates, intestate estates. Sometimes they hear adoption, incompetency hearings, things of that nature. If you wanted them to hear a divorce case, they could not hear a divorce case. They would not have jurisdiction, would not have subject matter jurisdiction. Same for a criminal case or wrongful death, for example, breach of contract case. All of those would not be able to be heard in a probate court because it is a court of limited jurisdiction. Courts are also divided into original jurisdiction versus appellate jurisdiction. And this is fairly easy. Original jurisdiction just means where a case is filed originally. Only trial courts have original jurisdiction as a general rule. And that means that, for example, again, in our state court system, our circuit courts are courts of original jurisdiction because they are trial courts. That's where you file the lawsuit. Trial courts are the only courts that have trials. Trial courts are the only courts that receive evidence, have witnesses testify, etc. On the other hand, you have appellate courts that have appellate jurisdiction. In our state court system, we have courts of civil appeals, courts of criminal appeals, and the Alabama Supreme Court, all of which are appellate jurisdiction courts. They do not have trials. They do not receive evidence or witness testimony. Instead, they review what happened at the trial court below. Generally, in order for appeal to take place and to be successful, the trial court usually must have made some error or some mistake, generally an error of law. For example, the trial court may have given an improper jury instruction, and upon appeal, the appellate court reviewed that to see if it was consistent with what the law allows. If they found a mistake, they could reverse the case, for example. or remand it, send it back for a new trial so that new jury instructions, proper jury instructions, could be given. In federal courts, in order to have federal court jurisdiction, you must have some statutory basis or statutory authority to allow the federal court to exercise its jurisdiction. There are a number of different statutes that give federal courts jurisdiction. The two most common statutes are summarized on PowerPoint slide number 8. The first one is federal question jurisdiction. And that means exactly what it says, that when there is a federal question, a statute, a federal law at issue, or if it's based on a treaty or the United States Constitution, at least in part, in other words, if any part of the lawsuit relates to that federal law, then you have federal question jurisdiction. That's all that matters. The amount does not matter for purposes of federal question jurisdiction. When you see the federal law in the case or in the fact pattern, you know the federal court has jurisdiction under federal question jurisdiction authority. The second one is a little more involved in that it requires two tests to be met, not just one. And it's called diversity or diversity of citizenship jurisdiction. And diversity jurisdiction requires, as I said, two things to be met. First, the plaintiff must be a citizen of a different state than the defendant. And in fact, all plaintiffs, if there are more than one, must be diverse in citizenship from all defendants if there are more than one. In other words, you could have, for example, 20 or 30 different plaintiffs and 20 or 30 different defendants. And as long as you did not have any plaintiff be a citizen of the same state of any defendant, then you would meet the first part of this two-part test. If you have a match on the plaintiff side with the defendant side, you have 19 plaintiffs that live in 19 different states or maybe even the same state, and then one plaintiff that lives in another state, and that plaintiff happens to live in the same state as one of the defendants, then you do not have diversity. That defeats the first part of the test, and you don't even need to go to the second part of the test. However, if you do have complete diversity, meaning all the plaintiffs are diverse in citizenship from all the defendants and there is no match on both sides, then you go to the second part of the test, which requires the amount in controversy. Basically, it's oversimplifying, but basically what the amount is sued for. If the amount in controversy must exceed $75,000. So if it's a small case, for example, they're suing for $25,000, then you will not meet the second part of diversity jurisdiction. If it's for $75,000, you still don't meet it because it must exceed $75,000. In other words, be greater than. Do not get confused, however, with the first jurisdictional statute, which is federal question. You can file a lawsuit involving a federal law for $25,000 or any amount less than $75,000 or any amount more than $75,000. The amount doesn't matter at all as long as there's a federal question. So that's just a one-part test. The diversity is a two-part test, and both tests must be met. Another way that courts are sometimes divided is in looking at concurrent jurisdiction or exclusive jurisdiction. Exclusive jurisdiction is when one court or one set of courts has the right, to the exclusion of any other court in the world, to hear a particular type of case. If there's a statute, for example, that says these cases must be heard in federal court, then they must be heard in federal court and they have exclusive jurisdiction. For concurrent jurisdiction to exist, that means that basically you have two or more courts that have the authority or the ability to hear the same case. We just spent a few minutes discussing federal court jurisdiction. For example, if you have federal question jurisdiction, let's say that we're going to learn about the Federal Fair Debt Collection Practices Act or the federal wage and hour laws. Well, those cases certainly can be filed in federal court because they are federal questions, and as a federal law is at issue, then the federal court will have federal question jurisdiction. However, I've mentioned a couple of times that our state circuit courts have general jurisdiction, which means they can hear practically anything. And in this case, yes, a state circuit court could also hear that kind of case. That means that that type of case and those courts would exist with concurrent jurisdiction because it could be heard by either a state court or a federal court. And there's a whole process of remand and removal to federal court when the circumstances exist, or it's really automatic, or remand if it was an improper removal. We're not going to discuss that. That's beyond the scope of this chapter. There's a nice Venn diagram on slide 11 that gives you a little bit of an example, actually a lot of examples of exclusive jurisdiction, both federal and state courts, and in the middle where the Venn diagram overlaps of concurrent jurisdiction. I like to think of venue as jurisdiction's weaker cousin. It's related to jurisdiction, but it just doesn't quite get there. Whereas jurisdiction is the power or authority of a court to hear a case, venue is just the most appropriate place for the trial to take place. Quick example. Let's say that there is a slip and fall that occurs at Walmart in Shelby County, Alabama. Well, the law says that you can sue a defendant corporate defendant in any state in which they do, in any county in which they do business, as long as you have jurisdiction over them. Well, that means that there's a Walmart in Jefferson County, there's a Walmart in Baldwin County, in Greene County, in Montgomery County, and Barber County, and practically every county, if not every county in the state of Alabama. And that means that Walmart can and is sued in all of those counties. However, where would venue be most appropriate in a slip and fall case involving a Walmart in Shelby County, Alabama? Well, when you think about it, the witnesses that saw that are more likely to reside in or close to Shelby County. The people that saw the slip and fall, the person that actually slipped and fell probably is a Shelby County resident. The manager who may have been responsible to make sure that the floor was not slippery and free of spills probably resides in or near Shelby County. The products used, the site itself in case it was needed to be inspected in Shelby County. Obviously, Shelby County would be a more appropriate location for a trial involving a slip and fall in Shelby County than, say, Baldwin County would in the Mobile area. And that's venue. Standing to sue is another requirement that must exist for a plaintiff, being the one that brings the lawsuit, for them to maintain the lawsuit. And standing just means they've got to have some stake in the outcome. They have to have some real interest at heart that allows them to seek redress or assistance through the judicial system. If you purchased a cup of coffee and it was 200 degrees and you got burned by that coffee, you certainly would have standing to sue. Your interest in seeking to be compensated for the injuries you suffered would be certainly a tangible interest sufficient to justify you seeking relief through the court system. On the other hand, if I, your instructor, purchased the same cup of coffee and I spilled the coffee or had it spilled on me and I was injured, and you felt very badly that I was injured through that spillage of coffee, and you wanted to sue the defendant who served me that coffee at that too hot temperature, because you felt so badly, the law would likely say you lacked standing. You don't have the interest at stake. I do. And because you lack that interest, you lack standing. It also, another part of standing is that it must be a real interest and not just an academic one or a theoretical one, or one that might happen. Well, if it might happen, let's see if it does happen. If it does happen, then standing actually exists. Well, I'm afraid that this defendant is going to they're going to put me out of business because of their parking lot, which I think is going to probably have a sinkhole develop over it or whatever. That's a very poor, rambling example, but your fear that something might happen or that they may do something in the future would likely render you not having standing, because it's a hypothetical controversy and not a real one that actually has existed. Slide 14 shows us a number of the states, of the court systems in the federal and the state court. You notice that the U.S. Supreme Court is the highest court in the land, and it is the highest court both in the federal court system and the state court system. It is the ultimate arbiter of all things, and we must follow the concept of legal precedence by virtue of whatever they have to say. Their rulings always prevail. Slide 15 is basically a review of general jurisdiction and limited jurisdiction in the state court system, but in the federal court system we have not really focused on that yet. The court of general jurisdiction in the federal court system is known as the U.S. District Court or United States District Court. In Birmingham we have the U.S. District Court for the Northern District of Alabama over on 5th Avenue North in the Hugo Black Building. Courts of limited jurisdiction in the federal court system are ones that can only hear certain matters, such as U.S. Tax Court, which hears tax controversies, U.S. Bankruptcy Court, which resolves bankruptcy matters, and U.S. Court of Federal Claims. In the federal court system, we have appellate courts prior to reaching the United States Supreme Court. I generally have a handout associated with this in the on the blackboard containing the Alabama State Courts and the federal courts, but I want to go ahead and mention this here. And that is that we have 13 courts of appeal in the U.S. Courts of Appeal, and those are the intermediate appellate courts in the federal court system. And we in Alabama, along with our neighboring states of Georgia and Florida, are all in the 11th Circuit Court of Appeals. We used to be in the 5th Circuit Court of Appeals, which sits in New Orleans and hears cases or appeals from U.S. district courts in Texas, Louisiana, and Mississippi. Instead, what used to be a 6-state circuit court of appeals was split by creating a new 11th Circuit in 1981. And when the 11th Circuit Court of Appeals was created, headquartered in Atlanta, the states of Alabama, Georgia, and Florida were assigned to the 11th Circuit. So if you need an appeal from the U.S. District Court in the Northern District of Alabama, for example, that case would be appealed to the 11th Circuit Court of Appeal. And I want to spend just a minute or two talking about the concept of precedence. And again, I often discuss this with the handout, but I'm going to go ahead and discuss this here as a refresher or in case you did not see this earlier. And that is, in our system of justice, we abide by the concept known as precedence. And that means that lower courts must follow the rulings of higher courts that are directly in their line. In our state court system, we have our state circuit courts and our state district courts, which I haven't mentioned, but state district courts, again on the handout, are courts that are limited to a maximum dollar amount in their jurisdiction and don't have a jury and have a short period of time to answer, etc. But our state district and our state circuit courts can be appealed to our circuit court of appeals, civil appeals, and our court of criminal appeals, or the Alabama Supreme Court. It's not our circuit court of appeals in the state court system, so I'm sorry I misspoke. It is the Court of Civil Appeals, the Court of Criminal Appeals, and the Alabama Supreme Court, and that's where they can be appealed to. Well, if a decision was rendered by the Alabama Supreme Court or the Court of Civil Appeals, for example, and a trial court, meaning one of our state circuit court judges, had a case in front of him or her involving the same issue, legal issue. Well, if the Supreme Court or the Court of Civil Appeals has rendered a decision on that legal issue, then our circuit court or district court judge must follow that because that is binding precedent. In the federal court system, because we are part of the 11th Circuit, our U.S. District Court for the Northern District of Alabama here, but all the district courts in Alabama, all the district courts in Georgia, and all the district courts in Florida must follow the binding precedent of the 11th Circuit Court of Appeal and the U.S. Supreme Court, of course. We have an unusual issue that's a little quirk, a little tweak that applies just to Alabama, Georgia, and Florida. And that is that not only do we have to follow the 11th Circuit rulings, but we also sometimes have to follow the ruling of the 5th Circuit Court of Appeals. And we have to do that when, in this situation, because we used to be part of the 5th Circuit Court of Appeals prior to 1981, if the 11th Circuit has not issued a ruling on a particular legal matter, and if the 5th Circuit has, but prior to 1981, prior to the split in circuits, then in that event, if the 11th Circuit hasn't ruled and the 5th Circuit issued a ruling prior to 1981, we must follow as binding precedent the 5th Circuit ruling prior to 1981. Now that's a lot that's involved. The 5th Circuit ruling, if it is after 1981, we don't care, because either the 11th Circuit has ruled on the issue, or even if it hasn't, the 5th Circuit ruling after 1981 is no longer binding precedent because we have our own circuit court. Just like we wouldn't have to follow the 9th Circuit or the 10th Circuit or the 4th Circuit or the 2nd Circuit. We would not have to follow the 5th Circuit either after 1981. In addition, we don't have to follow the 5th Circuit before 1981 if our circuit now has ruled on the issue. So a lot of situations must exist in a peculiar circumstance for us to have to follow the 5th Circuit, but it'll be important for you to know when we have to follow the 11th Circuit ruling, which is always, and when we have to follow the 5th Circuit, which is only sometimes, only in those cases prior to 1981, and only when those prior to 1981 cases involve some issue where the 11th Circuit has not ruled. And one more little quick example. You may be thinking, what in the heck am I talking about, ruling on an issue or whatever. Well, here's a quick example. In the law, in sexual harassment cases, a plaintiff may recover not only damages against the defendant, but also his or her attorney's fees may be awarded by the court against the defendant. Well, the question was for many years, are those attorney's fees that are recoverable to the plaintiff but actually go to the attorney, are those attorney's fees taxable income to the plaintiff? And some of the circuits says it was taxable, and some of the circuits said it wasn't taxable. In the 11th Circuit, the court used to say that it was not taxable, and that meant that if we ever had a case in the state of Alabama, in our district courts, or in the state of Georgia, or in the state of Florida, involving that issue, whether or not attorney's fees awarded in a sexual harassment case were taxable income, they must follow the 11th Circuit. Now, that example has been done away with because a few years ago the U.S. Supreme Court took the split in the circuits and they said, well, we've got some circuits that are saying it's taxable and some that are saying it's not taxable, so we're going to finally resolve this issue. And now, from now on, all circuits will have to rule the same way that we're about to rule. And they eventually ruled, just for your information, that it was taxable to the plaintiff. Okay, thank you for this. You can pick up with the slide 17 through the rest of the chapter on the next Integrity audio lecture.